Just take note on gun cases. It shouldn't be Democrat versus Republican. It should be, what are our inalienable,
Inalienable?
what are our rights? We are the Armed Attorneys. Today we're talking about a recent Supreme Court decision that is a First Amendment decision, actually, but really could affect gun people in some ways that we've seen come up for years in our firearms practice. Stick around to hear more about it. And before we get started, show your support for the Second Amendment by hitting the like button.
And today's video is brought to you by our friends over at SDI. Check them out, sdi.edu/armed-attorneys, online gunsmithing, armor, and so much more. sdi.edu/arm-attorneys. Now today we're talking about a United States Supreme Court decision that I'll say didn't get all that much media press in light of some of the other decisions that came.
Oh, no, it is decidedly not that sexy compared to other things that have happened recently from the Supreme Court.
No, but I think it has a kind of a big impact on gun owners, and we have to talk about it.
Well, because gun ownership, I mean, let's be honest, like, it's Second Amendment, but it's also First Amendment. I mean, there is so much about how we interact with our firearms in public that can be speech.
Oh, yeah.
Right? And so we've seen it come up in the Texas legislature. We've seen it come up all over the country. So it is, I mean, it's very, to me, I think it's very important.
Yeah, so we're talking about Counterman v. Colorado. This is Supreme Court case number 22-138, and this was decided on June the 27th, 2023.
Yeah, so don't get mad at us for not having a citation for it, because there is no citation for it yet.
Right now it's still just a slip opinion, but just a quick synopsis of what happened. So we have Billy Counterman. He was, the state of Colorado alleges that he was stalking this local performer from 2014 to 2016. He'd message her on Facebook. She'd block him. He'd create a new account.
Lots of online harassment.
Yeah, lots of online harassment. And even some kind of veiled messages like, oh, I hope nothing bad happens to you, kind of things like that. It disrupted her personal life. She stopped going out, stopped walking alone, canceled performances, all that stuff. So it disrupted her life. Colorado arrested him, charged them with their harassment law, convicted. Their appeals court didn't overturn the conviction, and their Supreme Court declined review. Now, this is where the United States Supreme Court steps in.
Right. And remember, when we have true threats, those are not fully protected by the First Amendment. That's why the state can and does prosecute them, right? I say to Richard, I'll kill you, I mean, if it's actionable and it's a real threat and there's all sorts of other qualifications that can come in based on your particular statute, your mileage may vary, you've got something that is not First Amendment protected free speech. I can be imprisoned for that. But we still must impose the correct standards. And so what we have here is a Colorado statute that essentially said it's a reasonable person standard as to whether or not you are committing this offense, as to whether or not your speech was in fact a true threat, was threatening, you can be jailed for it. And then the Supreme Court coming in and saying, no. You can't do that. It can't be just wholly objective, reasonable person. If you're going to put someone, in jail for their speech, for this true threat speech, there's got to be some component of that person subjectively understanding, okay, I know that what I'm doing is harmful, offensive, dangerous, etc.
Threatening.
Yeah.
And the context and we'll talk about all the different contexts this comes for gun owners, but we see this added subjective component is really important. And I got to give credit to Emily. She had her prediction hat on, and this is exactly one of those cases, if we rewind back not too far, where we get good decisions on Fourth, Fifth Amendment cases and First Amendment cases.
Yes. And
to time machine a little bit, talking to Emily about different issues when we have unanimous opinions from the Fourth or Fifth Amendment issues and First Amendment issues. That's when we see some really big steps forward in the law. Now, we don't have a unanimous opinion here, but we do have an interesting arrangement of the court.
Yes, constitutional rights should make strange bedfellows at the Supreme Court. It should. It is not political. Your First Amendment right, your Fourth and your Fifth Amendment rights, those should not be divided down party lines, just like your Second Amendment right should not be divided down party lines. So here we've got majority opinion. We've got Justices Kagan, Roberts, Alito, Kavanaugh, and Jackson, right? Well, that's a bunch that we haven't seen before. And Concurring in the same concurrence, we've got Sotomayor and Gorsuch, and then dissenting Thomas and Barrett. For those two to be connected is not particularly surprising, but that's great. That's how it should be. Our rights as citizens of this country should not be blue and red, right? We should have the Supreme Court. And, reasonable minds can differ. Their reasonable minds did differ, some slightly, some greatly, but it shouldn't be a party line decision. And so, I don't know, just take note on gun cases. It shouldn't be Democrat versus Republican. It should be, what are our inalienable, what are our rights, right? Okay, all right. Soapbox closed. Go ahead.
Well, how
does this affect gun owners?
Yeah, let's see what the court essentially held. They said the state must prove in truth at cases that the defendant had some subjective understanding of his statements' threatening nature, but the First Amendment requires no more demanding than a showing of recklessness. So they temper it just a little bit. But
yeah.
But what does this mean for gun owners? A whole lot of things, because we see a lot of people's sensitivities increasing in the presence of firearms. And I can't tell you how many people I've spoken to who the police come and visit them while they're walking down the street, or engaged in totally lawful behavior, but someone saw a gun in a holster, or maybe they're walking down the side of the highway leading a Boy Scout troop hike, and but in case they're attacked by a wild animal, maybe they have a long gun on their back, and the police are called on them because this person has a gun.
Right. So let's talk about recklessness, and let's talk about the example of, you are committing an offense, and virtually every state has some equivalent of this offense, in which you are displaying a weapon in a manner calculated to alarm, right? This gets held against gun people all the time, because a lot of times we want to go out perhaps to a protest, to something political, or maybe you're sort of creating your own political statement. You have an openly carried firearm with you. Well, if you are displaying it in a manner calculated to alarm, we can evaluate that in two different ways. Some states evaluate subjective intent. Some states evaluate objective, right? Would a reasonable person find this alarming? And so what we know from this opinion is, if we're going to make threats against people, and I think this can easily be converted to true threatening words as to threatening actions, right? Because it's still a First Amendment issue. Can we say that person is just simply objectively unreasonable? Objectively, this was going to alarm people? No, they have to at least have been reckless in their mens rea, as to say, essentially, I'm consciously disregarding the fact that my actions could cause this outcome being people are alarmed or upset or threatened. And so that's fantastic. Now, does it necessarily protect everyone? No. I would say, if you have planned your protest right outside of an elementary school where it was definitely reckless, if you didn't think people were going to be alarmed, maybe there are judges and there are juries who are going to find that subjective component. However, it's going to take some evidence. It's going to take some proof at trial. And I think that's incredibly important.
But what I think also stands out to me is just folks engaged in otherwise lawful behavior, because I can't tell you, and this, shows up primarily in states that, there isn't restrictions on open carry. So we see folks open carrying. We see these folks threatened with arrest, sometimes arrested because they're engaged in completely lawful behavior. They'll have their holstered handgun on their hip, and then somebody will feel scared and call the police.
Yes.
And I think that's why I think this is so worth talking about, because we have seen courts say, we're just going to evaluate this, as Emily said, through an objective reasonableness lens. Well, you know how people's sentiments are about firearms these days. You should have known better. Well, now we know that is not the case. There is more to it, and we have to look at what's in the mind of the person carrying. And I can tell you, having hung out with this community for some time, engaged in totally lawful behavior, exercising your Second Amendment rights, how are we supposed to know that that is going to threaten people?
Right. And this is just, yes, this opinion, although it looks like it's protecting internet stalkers, really not the case. Easily, directly transferable to something that does affect the Second Amendment community, that I think is just phenomenal. And again, applaud the justices for any time they put the politics aside and just do the right thing by our rights. The Second Amendment is just as important as the first, guys. So let's keep it up.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question, comment for us below. Do you think this is important for gun people? Do you think we've stretched too far? Until next time, we're the armed attorneys. Like Gail the snail. Okay.